Hi everyone. So it's 3 p.m. now. So we're just waiting for Zoom to let everybody in. So in the meantime, just give us 30 seconds before we get started. All right. So while we continue to wait for everybody to continue filtering in, I'm just going to do a quick housekeeping announcement. So this event is being recorded, and a copy of the event will be made available to you when it is over. Your cameras are off the entire time, but there is a Q&A section at the end of this. So I encourage you to type in your questions, and we'll try and get to as many as possible. Before we get started, I would like to do a land acknowledgement. So we recognize that many of us are joining from different places in Canada today, and we will not be able to acknowledge all the Indigenous lands our participants are living on. That being said, I would like to acknowledge that CCLA's office and the speakers for this event are in Toronto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee, and the Wendat peoples, and that is now home to many diverse First Nations, Inuit, and Métis people. In the spirit of reconciliation, we acknowledge the land that Indigenous peoples have lived on and taken care of since time immemorial. We are honored to be able to live and work on this land. So with that, I would like to turn it over to our Executive Director and General Counsel, Noah Mendelsohn-Aviv, to get us started. So Noah, over to you.
Thank you very much, Michael. And echoing Michael, I'd like to welcome each and every one of you to this briefing. And thank you for being here to learn more about CCLA's criminal justice program. By joining us today, you're part of an important community of people interested in knowing more about rights and freedoms in Canada. Some of you may simply be here to watch and listen and learn. Thank you for joining this briefing and for taking the time to find out more about criminal justice in Canada and about CCLA's work on this extremely important subject. Many of you are already part of our community dedicated to rights, justice, equality, and freedom for all people in Canada. Thank you for being here, as always, for being engaged, and for your ongoing support for our work. Criminal justice, in many respects, is one of the most difficult topics that we work on at CCLA. The subject matter is painful, and for many people seems unrelatable or unimportant. Much of what happens takes place in dark or solitary places and behind closed doors. It is particularly unrelatable for people who have the good fortune not to have frequent contact with police, not to have firsthand knowledge of carding or investigatory police encounters, not to know the criminal legal system as an accused person or a defendant, and not to have personal connections to correctional institutions. So the fact that you have chosen to attend this briefing says a great deal about your commitment to civil liberties and to justice. Thank you. We're very happy to have you with us. Before I introduce our wonderful speaker, I wanted to note that criminal justice is one very important part, but it is one part of what CCLA does. As many of you know from our website and other sources, we work to protect, empower, educate, engage, and stand up for the full range of rights and freedoms for all people in this country. This includes equality for racialized communities, like those who are stopped too frequently when driving, reproductive justice so that each of us has the autonomy to make our own choices about our own bodies, freedom of peaceful assembly so that students today, yesterday, and tomorrow can raise their voices about issues of concern to them, and so that no one can take away our democracy by shutting down civic space and discussion, and privacy and digital rights to protect the full range of rights in the virtual world, as well as the real one. CCLA's criminal justice program engages with Canada's criminal law, with its policies and practices to demand that these should make Canada healthier, safer, and more just for every person. So it is my great pleasure to introduce you now to Shakir Rahim, CCLA's brilliant criminal justice director. Shakir Rahim, in this role, oversees and executes advocacy strategies to protect and develop charter rights in criminal law, hold police accountable, and defend prisoners' rights. His work includes strategic litigation management, public outreach and education, and engagement with policymakers in a range of fora, which you're going to get to hear about today. Recently, Shakir played a key role in the civil society response to Bill C-48 on bail. Prior to joining the CCLA, Shakir practiced criminal law at Presser Barristers and Kastner Lamb at both the trial and appellate level. He also acted on significant public interest matters. Outside of court, he co-led the campaign to establish the independent civilian review into missing persons investigations. He advised public interest coalitions on advocacy strategy and regularly provided media commentary on criminal justice and human rights matters. Shakir is a member of the board of the HIV Legal Network. He received his JD from Osgoode Hall Law School, where he graduated with distinctions in criminal law, legal ethics, and community service. We're very happy to have you with us, Shakir, and I'm happy to turn the floor over to you.
Thank you, Noah, for the introduction, and thank you to everyone here for your support and your interest in our work in criminal justice. We truly could not do it without you, and having you at our back is an important part of driving our mission forward. Today, I'm going to focus on 3 different subject areas where the Canadian Civil Liberties Association has been active in the past year or so. The first is on bail. The second is on some of our more recent advocacy related to the Umar Zamir verdict, and I'll provide more information about that case. And the third is an important court intervention we were involved in related to police accountability. So I'll begin with bail. We have been on the forefront of responding to what is one of the most significant attacks on a charter right at the moment in Canada, and that is the Section 11E right not to be denied reasonable bail without just cause. At the briefing that I provided last year, this was in June 2023, I spoke to you about the forthcoming Bill C-48 on bail reform. This was federal legislation that would introduce more reverse onus provisions as part of the criminal code affecting bail. What is a reverse onus provision, and why are they problematic in the context of Canada's bail system? Before I precisely answer that question, I would just like to remind everybody about why bail is important from a civil liberties perspective. Before any evidence is heard in court, before any allegation is tested, before anyone has the ability to present their side of the story, bail is the only safeguard between an innocent person's liberty and a prison cell. So it is fundamental to ensure that our civil liberties are protected in Canada. Normally, it is the state that has the responsibility to prove why somebody should be detained pending trial. Reverse onus provisions change that. Instead, you have to be the one to prove why you should be released. This is an extraordinary reversal of the burden that is usually present in the bail system. Bill C-48 would have introduced more reverse onus provisions as part of the criminal code. And it did pass, and it did introduce those provisions, but I will discuss some of our efforts to temper the impact of the bill. It is important to remember that right now in Canada, a record number of people are denied bail. Approximately 70% of people who are in provincial or territorial jails are individuals who have not been convicted of the crime they are charged with. They have simply been denied bail for an outstanding charge. This places enormous pressure on people who are innocent to plead guilty in order to be released from detention. And this is compounded because of the terrible conditions in pretrial detention facilities across Canada. Judges routinely comment and note how these conditions are frankly anathema to human well-being. It is also important to note that the bail system already permits conditions to ensure attendance in court, public safety, and public confidence in the administration of justice. And bail can be legitimately denied if it is found that one of those three objectives would be at risk. So what did we do when it came to Bill C-48? We were a leader in the civil society response, along with other organizations, to this piece of legislation. The first issue, aside from the substance of the bill itself, came when the House of Commons passed the bill lock, stock, and barrel without any committee study. Usually, complex criminal legislation is studied in committee. That means that different experts and civil society organizations have an opportunity to testify and bring their views before Parliament. Important amendments can also be proposed to the legislation during committee hearings. This was a rare instance of legislation passing the House without any committee study. We publicly, along with other organizations, raised the alarm, and our concerns were directly cited on the floor of the Senate as justifying an intensive study of the bill and scrutiny before the Senate Committee on Legal and Constitutional Affairs. We testified before that committee and made many of our concerns known, which led to senators in the report on the bill noting the myriad of issues with Canada's bail system today. We also proposed, with the support of other organizations, the only successful amendment to Bill C-48. And it is an important amendment that I will explain to you now. There is part of the criminal code called Section 493.2 that was introduced in the last few years, which requires a justice in a bail decision to pay particular attention to the circumstances of Indigenous accused and other individuals who are from groups that are overrepresented in the criminal justice system. This is an important provision because we know, based on empirical data, that members of the Indigenous community and members of other communities, such as the Black community, are overrepresented in the criminal justice system and in being denied bail. However, as we noted before the Senate, this provision has had mixed uptake among justices in terms of recognizing and applying it. So the amendment that we successfully proposed makes it a requirement that in every single bail decision across the country, a justice specifically explain how they considered Section 493.2 of the Criminal Code and determined whether or not it applied to the person before them. What this means is that this important remedial section is no longer an optional choice or something that can be overlooked by a justice or a judge. It must now be considered on the record in every single bail decision. And our hope is that the result of our amendment will be to reduce or ameliorate the overrepresentation of some of the groups that I mentioned earlier. In addition to Bill C-48, we continued our advocacy by launching a follow-up to our landmark report on bail 10 years ago. This report is titled Still Failing: The Deepening Crisis of Bail and Pretrial Detention in Canada. It was authored by Professor Nicole Myers of Queen's University, Laura Berger, former staff lawyer here, and Abby Deschman, former director of the Criminal Justice Program. You can read the report and watch the press conference on our website, and I know that my colleagues will be distributing some of these links after this briefing. The findings in our report were dire. We noted that the proportion of people denied bail is at a record level in Canada, that the charter right to a timely bail hearing is often violated, that conditions in pretrial detention are dangerous and inhumane, and that vulnerable groups continue to be unfairly denied bail. We also issued a series of recommendations directed at both the federal and provincial and territorial governments about how to improve the bail system. One of those recommendations we have now formed into a petition that you can sign to let your views be heard in the corridors of power. And that petition is to call for more bail bed systems across Canada. A bail bed refers to having a place for somebody who is released on bail, who may not have regular housing, to sleep and to receive supportive services. This ensures that people can be released on bail who otherwise might not be because they don't have a fixed address. And it also ensures that where there are reasonable and appropriate conditions that are part of a release order, people receive support in order for those conditions to be met. So that is an overview of some of our work on bail in the past year. And we continue, of course, in all of our advocacy to press for the recommendations that we've outlined both in our report and in our brief and public work on Bill C-48. With that, I'd like to turn to another matter where the CCLA has recently been active, and that is our response to the verdict in the case of Umar Zamir and the surrounding circumstances of that case. Let me tell you a little bit about that case and the issues that it raised. Mr. Zamir was a person living in Toronto who was having a night out in the city with his wife and his family. He was charged with the murder of a police officer. And the allegation was that while Mr. Zamir was with his family in an underground parking garage, that undercover officers approached him, identified themselves as police, and that Mr. Zamir at that point chose to drive his car into the officers before him. At the time these charges were laid, there was a lot of commentary on the case by public officials and by the police. In particular, Mr. Zamir was released on bail at the time, and many people were outraged who have public roles in our society, including the Premier of Ontario, who specifically commented on that bail decision, and the mayor at the time. After a trial, it was very clear that Mr. Zamir did not commit the crimes that he was charged with, and he was acquitted by a jury. And many different issues related to police conduct and practices became apparent during the trial, some of which have ongoing investigations pertaining to them. After the verdict was delivered, where a jury, properly instructed, found that Mr. Zamir was not guilty, the chief of the Toronto Police gave a statement on the steps of the courthouse. And he noted in that statement that both he and the service were wishing for a different outcome. And the implication of that is, of course, that Mr. Zamir ought to have been found guilty. This raised serious concerns. It is not the role of the police to pass an opinion as to the guilt or innocence of an individual. It is not the role of the police to comment on the correctness of specific judicial decisions. And the actions of the chief of police undermine the authority of the jury verdict and cast an aspersion on Mr. Zamir and his character, who should be entitled to maintain and have the benefit of his innocence. It was also part of a growing trend that the CCLA has observed, where police make comments about whether individual bail decisions were right or wrong, often comments that may contain not the full picture or misinformation about the nature of the case. So we issued a public letter to the Toronto Police Service Board, the oversight body of the Toronto Police Service, in which we called for two things. First, the chief to apologize for his remarks and recognize explicitly they should not have been made. And second, for the police board to create a policy to ensure that in future cases, especially those that might not carry the same profile as the Zamir case, there are no comments that would undermine the authority of a judicial decision of this nature. Many others called for that apology, and the chief did apologize publicly in a meeting of the police service board. And we have continued our advocacy by directly engaging with the Toronto Police Service Board, its members, and its staff to create a policy on this issue. And while we are not there yet, we are hopeful that our efforts will lead to a new policy or direction on this issue. And we also hope that other police boards and oversight bodies across the country will be able to look at this new document as a standard that they too should follow. So I'll now talk about the last issue I'd like to update you on. And this is an intervention that the CCLA was involved with, where we appeared before the court in a specific case to offer our perspective on what we felt was an important issue in the public interest. The case in question concerns an individual named Ijaz Chowdhury. Mr. Chowdhury was an elderly South Asian and Muslim man with a history of mental health issues who was killed by police officers while they were responding to a call from his family for assistance based on his mental health needs. Mr. Chowdhury's family is suing the Peel Regional Police and the officers who responded to the call for wrongful death. In this case, the Peel Police Service sought an exceptional order. They sought an order to keep the identities of the officers who were involved in this case secret in the legal proceedings. As you may know, the open court principle refers to the notion that in our courts, absent a few very high standard exemptions, we know who the players are, who the parties are in a lawsuit, what they say. But this was an exceptional request. And it is one that is very concerning from a police accountability perspective. We argued that it is vital that the police know about allegations of police misconduct, that the public be able to identify repeat bad actors, and see justice be done, no matter the result. Fortunately, the court rendered a positive decision in this regard. It rejected the exceptional request by the Peel Regional Police Service to keep officers' identities secret in this case, and affirmed that it would be an extraordinary case where that protection would be granted, where there was a real discernible risk to the physical safety of officers. And we were also heartened to see that many of our submissions and perspectives were reflected in the decision. So with that, we'll turn it over to the Q&A. I hope that you found these updates helpful. Of course, we operate on a number of different matters in a number of different areas. So I do encourage you to refer to our website and our social media if you'd like to keep more of a day-to-day tabs on what the criminal justice program is doing. Thank you.
All right, everybody. So we have about 25 minutes or so for Q&A. So I do encourage you, if you want to ask any questions, we'll try and get as many of them as possible. Just you can type them into the Q&A section at the bottom. So Shakir, the first question I have for you from a participant is, why can't they replace bail with house arrest, like something like ankle monitors?
That's a good question. In fact, that is an available condition of a bail decision. So you can be released on an electronic monitoring bracelet. And that is part of one of the most onerous forms of release possible, usually house arrest. An issue, though, is where there is a case where that is the appropriate condition, you have to be the one who pays for the electronic monitoring bracelet in most cases. So what that means, of course, is that those who have the ability to pay might be released because they can afford to pay for that service. But those who do not have the ability to pay, and that is a group that is unfortunately overrepresented in our criminal justice system, would not be able to maintain their liberty and would instead have to spend time in a pretrial detention facility.
Okay, and our next question is a participant asking, saying something should be done about pardons. They had a pardon revoked based on allegation before they were tried in court. These charges prevent them from working and traveling, especially about old charges that are over 30 years old. So do you have any comment on our pardon system? Okay.
Sure.
Yeah.
So the CCLA has been involved and was a co-founder of a coalition called the Fresh Start Coalition. And if you Google Fresh Start Coalition, you'll see the website quickly come up for that group. And we are advocating as a member of that coalition for there to be an automated record suspension regime in Canada. And what that would mean is that if after the offenses you are charged with and your sentence is served, you have been on good behavior for a set period of time, that is to say, have not received any additional convictions, we are proposing that you automatically be granted a pardon in those circumstances. So we've continued to advocate for that. Unfortunately, we've seen more hesitance, I think, because of the changing climate in terms of how people are talking about criminal justice to that proposal. But we continue very actively to be lobbying the government to create that system.
Perfect. And the next question I have to you, with the housing crisis we're experiencing across Canada, um, do you notice there's any impact on our bail system? Or would this affect the bail system in any way or put it under increased strain?
Certainly, I think housing is something that intersects with the criminal justice system on a number of different levels. Particularly, in terms of bail decisions, again, if an individual does not have a fixed address, sometimes the court will look at that as a sign that they may not be able to be compliant with certain conditions or effectively monitored by the police if they are released. So certainly ensuring that people have access to housing is important with respect to bail decisions. And of course, more generally speaking, providing individuals with a home and with other forms of social supports ensures that they have stability in their life and support in their life so that if there is a risk of criminal conduct, that can be addressed by having those systems in place.
Right. Are you aware of any jury members in the Zamir case being hassled by police since the decision, or if you can comment on that, or
No, I'm not aware of that myself.
perfect. The next question is also if you can comment, do you know or have any idea when the Police Services Board will have a policy developed regarding the Zamir case outcomes?
Yes, so with respect to the specific issue that we're advocating on, that is how the chief of police and officers assigned to cases comment on cases that they are have the authority for. I would anticipate that we will see something
Mhm.
toward the end of the summer and in the fall. Of course, it's still very much an active negotiation and dialogue, so there's never a guarantee, but that is when we would hope to see the results of our advocacy by way of a policy or a directive.
Okay. And this is a good question. Isn't arrest more cost effective than imprisonment? Do they make people pay for house arrest because they treat it as a fine in addition to punishment of house arrest? So is them having to pay for house arrest part of house arrest, I guess is the question, secondary question on that. But I guess the primary question is house arrest a more cost effective measure than imprisonment?
Yeah, so to clarify, you don't have to pay for being on house arrest, but in certain jurisdictions, you do have to pay for electronic monitoring bracelets if that's part of your release order conditions. But you are correct that it is certainly more cost effective to not have somebody in a pretrial detention facility. There is added cost to that. And frankly, it's also better from a public safety perspective. We know that because of the dire conditions in prisons, they can actually be something called criminogenic. That is to say, they can increase the likelihood of criminal behavior in the future rather than decrease it because the conditions are so poor, because people are taken away from their family, their employment, their day-to-day life and their routine. And so it's important when we think about rehabilitation and the day after somebody serves their sentence, if they are found guilty, that is, uh, or even if they're released and they are found not guilty, that we actually haven't set them up and set our society up for further challenges down the line.
Okay. And the next question, in regards to segregation units, what's happening with them, and are they still getting around it by calling them stabilization units? I know we've done work on segregation units in the past.
Yeah, there are still a number of issues with how segregation is practiced. We have made our views known about some of the different names that they've put or different kinds of conditions that still don't necessarily deal with the underlying issue of solitary confinement. And what I'll do is I'll ask my team to share some of those resources with you after this call so you can read about our concerns more specifically.
Perfect. So we have a representative from the John Howard Society of Canada, which is a great organization we've partnered with in the past. They write a blog post on criminal justice issues. Their question is, given the pending federal election, how can we, CCLA and others, build a stronger alliance among the many people and organizations who recognize the fallacy of the tough on crime agenda? It feels like there are many people and groups who see this but are all working separately.
Well, that's a great question, and thank you for being here. We do have the pleasure of partnering with John Howard Society of Canada on many issues, and I've had the pleasure of working alongside Catherine Latimer, your director, on a number of occasions. There is a challenge in terms of creating coordinated groups to respond to some of these issues, but they are out there. So, for instance, with respect to Bill C-48, as I mentioned, many organizations came together, the CCLA, the John Howard Society, Canadian Association of Elizabeth Fry Societies, Black Legal Action Center, Aboriginal Legal Services, Indigenous Bar Association, and we coordinated very well on our efforts. And so you can rest assured that those discussions are happening about how we can create alliances to affect change. But of course, we are in a nonprofit sector generally, and so it can be a challenge sometimes to have the resources that we need, but we do our best, and I'm heartened to say that there are a number of those kinds of cooperative efforts out there.
Okay. So next question, they're asking, I understand that judges have to consider Indigenous backgrounds, but what about other racialized or minority groups? Or do their backgrounds have to be considered as well?
Yes. So with respect to bail decisions, the amendment that I spoke about pertained to something called Section 493.2. And this requires that the conditions of those who are vulnerable and overrepresented in the criminal justice system are also considered. And there have been rulings that includes, for example, members of the Black community, racialized community, those with mental health challenges. So there is consideration of those groups as well in bail decisions and also as part of sentencing.
Perfect. Can you be denied legal representation for a court hearing?
Sorry, can you repeat that?
They're asking, can you be denied legal representation for a court hearing? I'm assuming this is around bail, a bail hearing.
So everybody has the right to be represented by counsel in a criminal proceeding, but there are cutoffs to legal aid. So if you make below a certain amount of money, you will not receive a publicly funded lawyer, but have to pay out of pocket. And certainly that is a major challenge in terms of ensuring effective representation, because even for those who might earn slightly above the legal aid cutoff, hiring a lawyer can cost an enormous amount of money, and they may not have the ability to pay those fees and also continue to support themselves day to day.
All right. And the next question I have for you is, what do you personally think or about Canada's criminal harassment law being used to punish Canadians for legitimate free speech, and even to suppress the free speech of Canadians in one way or another via court-imposed conditions?
Well, I think anytime we see a criminal charge laid in relation to a freedom of expression issue, so for example, in relation to a protest, we have to carefully scrutinize what the allegation is and ensure that these charges are not being laid to suppress protest or expression. And of course, we have seen that happen before. And when it does happen, we speak out against it. So I think anytime we see criminal charges laid in relation to a protest, it's important to scrutinize what the allegations are and what the motivations might be for the laying of those charges.
All right. The bail system is supposed to protect the presumption of innocence. How can we ensure it continues to do so?
Well, there are a few different steps that can be taken. First, by continuing to oppose the introduction of the reverse onus provisions, which I spoke about. That approach, where the burden is on a person to prove they should be not detained or should be released, does not align, in our view, with a robust protection of the presumption of innocence. And second, it is to ensure that we have a functioning bail system. As our bail report sequel, bail report that is outlined, there are a number of challenges with respect to how the bail system currently operates, from funding, procedures, the mentality of judicial decision making, that collectively mean that the presumption of innocence and the role that bail has to uphold that is not occurring. And so I'd encourage you in the follow-up report, which we will also send out for you to read, to see those recommendations. And I think that would be the answer to your question.
A big issue is that people with mental health problems. A big issue is that people with mental health problems when committing a chargeable offense. Police don't have any discretion or sometimes don't use their discretion. What has been done to help them during the process? So I guess this question is asking, what are police doing? What's the process for people around bail for people with mental health, no mental health issues?
Well, there are a number of possible ways that those individuals can be supported that are not presently occurring. So when we talk about having adequate supports in the community for those released on bail, someone that has a mental health issue, depending, of course, on what it is, may benefit from, let's say, having supportive counseling services or having a wraparound program of support providers for their healthcare. And we know that those kinds of programs right now are often underfunded and under-resourced. So ensuring funding for organizations that can provide those types of support is tremendously important. So that's one thing. The other aspect, of course, is that there is an enormous amount of discretion in the system. The police have the discretion on when to make an arrest. Justices following the law have the discretion in terms of making a bail decision or imposing certain conditions. And so what's important is that there is a proper and meaningful consideration of how an individual who might have mental health challenges can have their needs effectively addressed, and that they aren't effectively punished simply for having that condition. And so I think that would be where there could be a meaningful consideration of those issues.
Okay, so this is an excellent question, ties into the work we're doing. Are there any initiatives in place to educate members of groups overrepresented in the criminal justice system regarding their civil liberties?
That's a great question. And there certainly are different initiatives that are ongoing in that respect. So in Ontario, for example, and in other provinces and territories, there are ethno-specific legal clinics that often do public legal education. So, for example, here in Ontario, we have the Black Legal Action Centre, Aboriginal Legal Services. They often educate members of their communities about what they need to know about with respect to the criminal justice system. We also, of course, as the CCLA, have different resources that touch on these issues. We have a guide relating to protest. We have a guide relating to knowing your rights with respect to police stops and race. And so I'd encourage you as well to read those resources. And those would be some of the materials and work being done on that important outreach.
Perfect. So this next question, what options are available if you believe Criminal Code Section 493.2 was not considered in a bail decision? So maybe let us first of all know what that section actually is for the non-lawyers here, and then what options you think we have if there is you believe that was not considered in a bail decision.
Certainly. So that is the section I spoke about, which requires the consideration of circumstances of Indigenous individuals and those who are vulnerable and overrepresented in the criminal justice system. If that section has not been considered, there have been cases correctly that have held that's an error, a legal error, and the decision has to be reconsidered as a result. And in particular, now that the criminal code, through our advocacy, includes the requirement that consideration is made to Section 493.2, that would be another reason for a court to look at that. So that's something that really you'd want to flag for your lawyer in order for them to advocate as to the proper remedy.
So we have a comment and a question. So first, I laud the CCLA's amazing work in advocating for a more equitable justice system. So thank you. We really appreciate that. Considering the formidable inequality baked into the Canadian justice system, can you provide some sources of justice reform inspiration from more equitable, progressive, restorative, and truly holistic systems in other places, if there are any?
Yes, I mean, regrettably, I don't think there is one jurisdiction we can point to and say that's how you get it done. There are so many of these issues that are pervasive across different jurisdictions, but there are different things that we can point to that could be models to follow. So, for example, you talked in your question about restorative, equitable, progressive systems. In our own country, we have seen really meaningful work done by Indigenous groups with respect to sentencing outside of the strict criminal process. So whether that's including restorative justice at any stage of the criminal process, before someone is charged, after they're charged, as part of their sentencing, we've seen that has had a lot of benefits for those communities, both in terms of preventing future conduct and in terms of having a holistic process in place. There are also, I think, from other jurisdictions abroad, examples of better conditions, of course, in correctional facilities. So we've seen in some other countries like Norway a very different approach to the emphasis placed on rehabilitation in prisons and the programs and supports and services available. So certainly looking to world leaders who are ensuring that there's real rehabilitation and upholding human rights happening in their correctional facilities is another place to look to.
What if you have a disability and can't afford to pay bail?
So bail, generally speaking, does not require an accused person to pay an amount of money. They may have to pledge to pay an amount if they violate their bail, or a surety, that's to say someone supporting them, may have to pledge an amount. But it's not the case that you have to pay for bail as such. But certainly, if there's any aspect of uh, being in the criminal process or receiving bail where a person's disability is an issue, that's something important to raise with your lawyer and have that conveyed to the judge so that there can be conditions proposed or a decision crafted that takes into account that consideration.
Okay. We have seen the use of the criminal courts to suppress the freedom of the press and the ability of reporters to do their work in Canada. Can you comment on this? Um,
Maybe that's something I can turn over to our executive director. Sort of concerns more of our fundamental freedoms work more broadly.
Yeah, thank you very much, Shakir and Michael. The question of suppression of speech generally is one that we are extremely focused on. Is the question what can be done about it?
I think there were are any comments on our yeah, what could be done about it, I guess is the
Yeah,
question.
with journalists, I think.
Yeah.
I mean, I think there's a great deal that needs to be done. One of the things that CCLA does, of course, is if there are large protests, we try and set up monitoring situations. We are small, and we're grateful for all the help and volunteers that we can get when there are those kinds of events going on. And sometimes we set that up. Um, we certainly provide resources to people, as Shakir was mentioning about the right to protest. And there are legal options that are available for people. But unfortunately, our system is not perfect. There is a great deal that we need to do and a great deal that we need to continue to do, be vigilant on. So it's wonderful that you're all here to be part of that, because that vigilance is what is going to protect our civic space. It's what's going to protect our freedom of expression moving forwards. It's not a perfect answer, but we live in a very human world and a very human country, and there are limitations that we are constantly working to try and overcome.
Thank you, Noah. So I have a question that's back and related to criminal justice now. It's a bit tricky. So it's just long. So she's an Indigenous woman, and she's been racially profiled by a police officer. They're now suing the police officer and also the police chief. She's also a researcher as well and working on her PhD. I noticed, and she's noticed in this that addictions may put a lot of Indigenous people in the court system. What she really wants is to become part of the radar of people, um, for they were racially affected. So, she's asking for any kind of resources for putting this on the radar for the issue of addictions, how this affects Indigenous people in the criminal justice system, where you would recommend she maybe go next to talk to people, or where she could look for further information on this.
Yeah, so certainly for the issue pertaining to how Indigenous people experience the criminal justice system, I think that that information can really be helpfully found by some of the Indigenous specific legal organizations that do advocacy on these issues. So I'd commend to you the website and as an organization, Aboriginal Legal Services, the Indigenous Bar Association of Canada has also weighed in certain instances on criminal justice matters. With respect to the impact of substance use, There are also a number of different organizations that have weighed in that regard. I think to ensure that we have a precise list, it's something that we can share in our follow-up links that we're distributing. But there are organizations that deal with both mental health and, to a lesser degree, different types of substance use issues that might exist, like the Empowerment Council, that have also put out resources or commentary on these issues. And so I think reaching out to some of these organizations and seeing the work they've done is a good place to start.
Okay, so this question, and it might be better also for Noor to answer. Um, with the what resources organizations like the CCLA need? We've been mentioning that we're a nonprofit, that like resources oftentimes we struggle for funding as a sector more generally. Like, what resources do you think are more needed in this sector generally?
For CCLA? Is it
For CCLA and every other organizations, any nonprofit that works in kind of our area.
It's an amazing question, and
Mhm.
thank you for your engagement and for wanting to know that, because it is critically important. I think for every organization who's doing this kind of work, certainly including CCLA, I'll start with CCLA because I know it best, and that's where we are. We're independent. In order to be a watchdog that watches government and monitor what's happening, we don't solicit government money. We're funded by private individuals like you, some small foundations, but there is so much more that we could do with greater resources, and we do a huge amount. You probably see us in the news. We certainly punch well above our weight, but more resources would allow us to do more. So that's one piece of it, and that's individuals um, supporting us, telling their friends, bringing in their communities. But the work is not just supporting CCLA, it's also sharing CCLA's work, um, our messages. We try and provide as much information as we can, be accountable, be transparent to the public so that the public can be engaged. And that includes all of you. And that includes you sharing that with your communities. Because when the public is engaged, when the public is informed, especially about things like the criminal legal system that does take place in solitary and dark places, as I was saying, behind closed doors, we have the opportunity, all of us, all of you here, to shed a light on those things by sharing information that we have and by making sure that it is of interest to the public. When it's of interest to the public, it'll make it more into the press. When it's of interest to the press, it reaches more of the public. And when it does, then it reaches the decision makers. And that is the value of a democracy, that we can make a difference. So sharing the information, sharing resources, peer-to-peer fundraising is available, certainly at CCLA and at other organizations as well. We've got an upcoming walk. And I think many organizations would say the same. Social media makes it very easy to distribute information and material. So thank you again for the question. I know it's not a substantive one, but I get that you understand that there is a great deal for all of us to do.
No, this one's also for you, because it's regarding to freedom of expression, and how it relates to the recent situation. What's the CCLA's position regarding injunctions being used to suppress peaceful public protests and other free expression?
Yeah, CCLA has been around for 60 years, and for 60 years we have seen people come out and protest on university campuses, in public squares, in all sorts of settings for a whole variety of rights and freedoms for themselves and for other people, whether it's racial justice, whether it's reproductive justice, whether it's environmental rights, indigenous rights, um, whether it's on issues of foreign policy related to the war in Gaza, which we're seeing right now, and who knows what there will be more of in the future, we always need the ability to peacefully protest. We always need our civic space to be available, yes, to drive our cars on, yes, to walk down the sidewalks, yes, to have Santa Claus parades and marathons that shut down the streets and make things a little awkward and uncomfortable, but we need civic space as well to be able to talk to each other. It's an antidote to the echo chambers. It is a critical part of a healthy democracy. And so we take a very strong position that peaceful protests should be supported, should be protected, for example, on university campuses where students are using the spaces on their own campuses to have their voices heard. We have heard of one injunction that is a little bit different because it was restricting only time, place, and manner. So making sure that there was access to doors, fire marshal access, safety access to windows in case people had to get out of buildings. So those kinds of restrictions we don't take issue with, and they make good sense and they seem reasonable. But we do believe that outside of time, place, and manner, it is important that we continue to have a healthy and a vibrant and a safe democracy now and into the future.
Okay. Thank you, Noah. So this is an excellent question to end on. It'll be for Shakir. In order to try and make a difference about this issue, who should I speak to? Should I speak to my MP? Should I speak to my MPP or who? So this is the last question we have. So Shakir, after you're done with this, if you want to do a quick wrap up before we pass it over to Noah for final remarks.
Sure. So that's a great question. And the answer is both. It's always important to write to your government representatives and make your views known. And if you look at our public updates about the work we're doing with respect to legislation, we'll often note, are we appearing before a particular committee in the House of Commons? Are we addressing a particular civic body? And we would encourage you to feel empowered to contact those same bodies and the individuals who sit on them to make your views known. Elected officials do care about the views of their constituents. And it does matter for us who are involved in this advocacy that not only are we representing organizational views, but that individuals and all the people who make up our country are seen to be active as well. And so certainly would encourage you contacting any elected official on these important issues.
Perfect. And do you have any final remarks before we pass it over to Noah?
No final remarks. I just want to thank everyone for their thoughtful questions, for joining us, for listening to us. As always, please do follow us so you can keep updated on the work we're doing. And we hope, and I hope the next time we have one of these wonderful briefings that we'll have further good news to share about the work that we've done and the accomplishments that we've had for civil liberties.
All right, Noah, over to you.
Thanks very much, Michael and Rosemary, for organizing this. And Shakir, thank you so much for taking us through all the incredible work that you're doing and for your brilliance in being able to field so many questions on so many different criminal justice issues. I mean, it really shows how very valuable you are in the work that you're doing is that you're able to address it because it really is a wide range. And there is so much to do. And as Shakir said, we have updates that we provide on an ongoing basis. So if you want to see how these cases are progressing, how the issues are progressing, you had questions, you were curious about them, that is available on our website. And we post often about this issue and about the other important work that we're doing. So I want to reiterate what we said earlier. Thank you to each of you for joining us today. Thank you for your engagement with the issues. Thank you for being interested. Thank you for those excellent questions. And thank you for every way in which you have supported, in which you continue to support CCLA's work, whether it's through signing one of our petitions, making a donation, or if you're a monthly donor for making a donation every month, for sharing our posts, for involving your communities. We are grateful for anything and everything that you do and that you can do to help spread the word of civil liberties and justice.
All right. So it's almost 4 o'clock, so I'm going to wrap it up with the final bit of housekeeping. So this was recorded. We will make it available to you at the end within a few days. We'll send it via email. There also was some requests for information, so we'll make sure to make those available in that email as well. So thank you everybody again for coming. We hope to see you again in the next few months when we have our next program briefing. So end it there. Thank you.